Sir Lawrence.
May it please the court. As the court knows, I appear for the defendant, who is the appellant, and I appear with Ms. Evans, King's Counsel, my learned friends, Mr. Flenley, King's Counsel, and Ms. McMahon appear for the respondent. This is, as the court will know from the skeletons, of course, this is my client's appeal against the decision of Mr. Justice Knowles, in which his lordship found in favour of the claimant companies. It is common ground that they had been defrauded by a solicitor called Stephen Jones, who is now, I understand, in prison, who practised through a number of entities that can be compositely referred to as Jirehouse. Jirehouse was insured by the appellant. As the court knows, Mr. Jones had at the relevant time one partner, using that term broadly to encompass the position of a member of a LLP and a director of a limited company, whose name was Viancé Prentice. The appellant Axis sought to justify its decision to refuse cover on the basis that Mr. Prentice had condoned relevant wrongdoing. In the alternative, it argued that it was entitled to aggregate two matters or claims, as it was put by the claimants, with the result that its liability was limited would have been limited to £2.75 million. As the court knows, the learned judge rejected both arguments, and we contend on this appeal that he was wrong to do so. With that very brief and I know largely unnecessary introduction out of the way, I think I need to turn immediately, and I very much hope that this can be dealt with very shortly indeed, to an application in relation to documents.
Well, if I can help you with that, Mr. Lawrence, we've considered it, and our view is that you should just carry on, use the documents. We've read the applications, and we think that's the best course.
I'm very much obliged, my lord.
And that applies to both applications.
Indeed, as your lordship knows, the respondent's application was unopposed. So unless my learned friend wishes to rise to his feet now and seek to persuade the court to take a different course.
No, my lord.
Thank you very much.
Which he wisely does not.
Whilst we're on housekeeping, can I just mention we're grateful to the parties for cooperating with a Friday morning hearing, because unfortunately the court can't sit on Thursday afternoon. But just, there was some confusion, I think. We will just sit normal hours, except we will sit on Friday morning rather than Thursday afternoon.
Exactly, Lord. At one point I had thought that the court might sit until 3 on tomorrow, but that's not right. The court sits until 1 tomorrow.
Just to be clear, what we'd said was that we could not sit any later than 3 on Thursday afternoon, which is why we were seeing whether the parties could sit on Friday morning instead of Thursday afternoon. Sorry if that caused confusion.
No, it was my fault. I simply misunderstood the position. But I understand it correctly now, and my own friend and I have communicated cooperatively in relation to timing, and the plan is that I should try to complete my submissions today. I do have quite a lot of ground to cover,
yes. And
it is possible that I will go into tomorrow morning, but if I do so, I shall have to ensure, in order to give my own friend enough time, I shall have to ensure that I finish very early stage tomorrow morning. Possible I might need a few minutes to tidy up a few loose ends tomorrow morning. My own friend will then have the rest of tomorrow morning, and he will have most of Friday morning. And we've discussed the length of time that I might need for any reply submissions, and the present plan is that I should have at least 30 minutes, but we will see how we go in relation to that.
Can I just check? I gave permission for one. I can see that there is a transcriber in court.
Yes.
Are they seeking to have a break?
Yes, my lord. I've spoken to the transcriber, and if the court is happy with its course, the proposal is that we should have a 5-minute break at about 11:45.
Yes, I'm content with that, but let's keep it to 5 minutes.
Yes, indeed. Indeed. Well, that's most helpful, and I'm very relieved to find that we are having, as it were, a clean start, and I'm grateful to the court for that. May I indicate the proposed running order of my submissions to check that it finds favour with the court, or at least doesn't meet with significant disfavour. I must admit I had initially thought that it made sense to start with the point that potentially disposes of the entire case, which is condonation, and then deal secondly with aggregation. But I've changed my mind about that. And I do propose, unless I'm directed or urged to take a different course, to start with aggregation, because that is a more tightly defined issue. I can certainly deal with that by lunch, and I hope before lunch. And in dealing with it that way, I will be able to acquaint the court, to the extent that it's not already acquainted, with the facts of the fraud or frauds in some detail, make my submissions about the law on aggregation, which, as I say, are quite nicely confined to about two authorities. And then, with that done, and dusted, I hope, and then move to the much more challenging topic of condonation, which, of course, raises all sorts of difficult issues about appellate restraint and what this court can and can't do, or should and shouldn't do, in relation to an attack on certain findings of fact.
Yes.
So, if yes. Unless that's very inconvenient, that's the.
I think we're quite content that you choose your own running order.
Thank you.
Obviously, we've read the skeletons carefully, and as far as aggregation is concerned, I think we're very familiar with the point. As far as the appeal on the facts is concerned, we quite understand you're going to have to develop your argument in some detail.
Yes.
One thing to say, of course, is that we are very familiar with the appellate approach to appeals on fact. Very, very familiar. But you must take your own course as to how far you need to get into that.
I was going to take that as a given, my lord, because I'm well aware that point must arise in this court again and again. I was, in relation to that, I was going to cite, but unless asked to do so, not actually go to, the very helpful passage in Group 7 and Nazir, which in turn sets out the very helpful and authoritative passage in Elisabeth in the judgment of Lord Justice Leggett, as he was. And in our skeleton, we've cited all that material, not because we considered that the court would need assistance about that, but because we thought it important that the court should know that we recognise that we do face a task that may be fairly challenging, it may be very challenging, because we are, in certain respects, appealing against findings of fact made at first instance, and we fully recognise the principle of appellate restraint, and I will seek, probably this afternoon, when I look closely at the learned judge's judgment, I will seek to persuade this court that this court should conclude, that the learned judge was plainly wrong in the sense in which that phrase is used in Elisabeth. And I will try very hard to avoid argument that seeks to engage the court's interest in relation to nitpicking points of detail involving minute issues of construction of certain documents and emails and so forth, because I am proceeding on the basis that that sort of criticism of the learned judge's approach may well struggle to gain traction in this court. I'm going to try to present a rather more broadly based critique of the learned judge's approach to this, in some respects, difficult case. May I, before then getting into the topic of aggregation, may I just make one or two very brief introductory observations? Counsel opening appeals are sometimes a bit too swift to say that the appeal raises issues of general public importance, but it probably is fair to introduce this appeal by drawing attention to the fact that the outcome of this case, this court's judgment in this case, will be of considerable and general interest to those who are concerned with the insurance of solicitors in this country. That means, of course, that it will be, if I'm right, it will be of considerable interest to the Law Society and the SRA, and it will be of considerable interest to the insurance market, within which, obviously, one finds the qualifying insurers who offer insurance on the minimum terms to solicitors. The reason why, the justification for the suggestion that it will be of considerable interest in those respects is really this. So far as aggregation is concerned, the sub-clause on which I place almost all the weight or burden of my argument is that which was considered by the Supreme Court in the case that is normally referred to as AIG, although the title of the Supreme Court decision involves the name Woodman as well, but I shall refer to it as the AIG case. I know the court will be familiar with that decision, and I know that in particular, I think I'm right to say that my Lord Justice Phillips was in the Bishop of Leeds case, which, am I right or wrong about that?
If I was, it has faded from my memory.
Is that right? Maybe, I may be wrong. We'll see. Anyway, we won't be going, I think, directly to that case, so it doesn't matter. But the subclause in the aggregation provision on which I focus was introduced in about 2005, as we'll see, as a response by both sort of combined response by the Law Society and the relevant insurers to the decision of the House of Lords in the TSB case, which was concerned with a different subclause in the aggregation provision, and which, in the judgments of Lords Hoffman and Hobhouse, adopted an interpretation of that subclause, which the insurance market regarded undoubtedly as disappointingly restrictive. The result, as we'll see, was that there was a negotiation between the market and the regulator, which led to a reformulation of the aggregation provision in the minimum terms. And since then, so far as we can tell, the new wording that we will be looking at closely in this case has only been considered in the AIG case, certainly in any substantial and helpful way. And the reason for that, almost certainly, in fact certainly, is that the majority, I think my learned friend would agree with me about this, we're both familiar with this point, I think, the majority, possibly the vast majority of policies of this nature, solicitors' PI policies, contain an arbitration clause. So issues about aggregation and indeed issues about condonation tend to be arbitrated. That is why there is a sparsity of case law. The AIG case, as the court will know, considered the meaning of the provision, but did not apply the provision to facts as found at first instance, because it was a piece of litigation that was based on assumed facts. And the matter, in fact, had to be referred back to the commercial court judge to be decided in the light of the guidance given by the Supreme Court, and there has been no further decision, so I assume the matter has been settled. Accordingly, this is we believe, this is the first occasion on which any court, let alone the Court of Appeal, has considered the application of this wording to facts as found or established at trial. So there will be considerable interest in that aspect of the case. So far as condonation is concerned, again, there isn't much case law to guide parties, insurers, regulators, and arbitrators as to the operation of the dishonesty exclusion, and in particular as to the operation of the condonation limb of the dishonesty exclusion. Two first instance cases have been cited in the skeleton arguments. There are one or two other first instance cases which I think the parties have concluded do not add to the debate, and that's it. The point that issue or that set of issues has never reached this court before, so far as we can tell. I make those opening observations.
But I had understood that part of your appeal was challenging the judge's findings of law in relation to condonation.
Your Lordship, sorry, had not understood that.
I didn't understand that the test for condonation was in dispute on this appeal.
No, well, it's not being disputed. Well, it is and it isn't. I'll develop this more fully when I come to condonation. In one respect, my learned friend, by his respondent's notice and his skeleton, does challenge one aspect of the learned judge's decision, I think I'm right to say. And that, in short, concerns this point. We submitted that in order to make out condonation of a dishonest or fraudulent act or omission, it was, or at least on the facts it could be, sufficient to prove condonation of an improper course of conduct of which the relevant dishonest act or omission was an illustration.
And that was the argument the judge accepted?
The judge accepted that.
Yes.
My learned friend will seek to challenge that,
I see.
I think, when he makes submissions.
Right.
But there is also a further issue
Blind eye knowledge.
to be considered. Well, blind eye knowledge, certainly. There is unanimity as the test we both go to. We both rely on Nazir for the relevant test. It's accepted that it involves the concept of focused or targeted suspicion and then a deliberate decision not to inquire for fear of finding out or getting confirmation of what one suspects. We agree about that, but there are certain nuances in relation to blind eye knowledge which will need to be considered. But before one even gets there, or perhaps after one's dealt with that, there is another issue, as I read the skeletons, there is another issue in relation to the concept of condonation and how it operates in this area, which is essentially this. The learned judge expressed his or explained his conclusion on two alternative grounds. First, he held that there had not been relevant blind eye knowledge. That finding will be the subject of sustained challenge in the course of the day. If that cannot be undermined or successfully challenged in this court, then that's probably an end of the issue of condonation. But the learned judge, perhaps mindful that his finding that Mr. Prentice did not have relevant blind eye knowledge might look perhaps a little curious given the very damaging nature of other findings made against Mr. Prentice, including the crucial finding that he was somebody who was unsuited to be a solicitor. The learned judge also set out a second alternative ground for his conclusion that condonation had not been established here. And that, in a nutshell, was that even if Mr. Prentice did have some relevant guilty blind eye knowledge, it was limited to to use a neutral term, a misuse of client funds by Mr. Jones that was or appeared to be intended to meet temporary exigencies, in the judge's phrase. And that, even if that blind eye knowledge could be proved, that, the learned judge held, would not be sufficient to prove condonation of the relevant dishonest acts, which of course involved a multi-million-pound fraud/theft. And the parties are divided about that. I will be submitting that the learned judge's analysis there was erroneous, and I expect my learned friend will be seeking to support it. So there are arguments about condonation, the principles of condonation and the concept in those areas. I hope that's helpful.
Yes. Just to say, I've refreshed my memory of what I always think of as the Dixon-Coles case, and I remember it well.
One could call it Mrs. Box's case, because she was the villain in that case. Yes. The Bishop of Leeds was a claimant, or his diocese was, but indeed that was the alternative name. Indeed, not. Yep. Well, I'm relieved that I wasn't entirely wrong about that matter. The second matter that I should just mention very shortly before I turn to deal with aggregation is this. There is lurking in one or two submissions, written submissions that my own friend has put before the court, a relic of an argument that he made to the learned judge below after Mr. Justice Knowles had granted unqualified, unfettered permission for an appeal. We will see in due course whether my learned friend seeks to make anything of the arguments that he advances. He suggests on occasions that in some ways the permission to appeal that we have is regarded as qualified or limited only to the draft grounds of appeal that were placed before Mr. Justice Knowles. With great respect, he's quite wrong about that, and I will simply place on the transcript the relevant reference. The relevant reference is what is called unagreed bundle tab 25, page 169, which contains an email from Mr. Justice Knowles, which confirms that we have unqualified permission to appeal, and the grounds of appeal are not confined in any way. I'm told that's the wrong tab number, tab 26, thank you. So it's, yes, it's tab 26, 169. So we will see. I'll say nothing more about that at the moment. We will see if that turns out to be a genuine issue. May I ask whether the court is working electronically or with hard copies or?
Hard copies.
I think we're all working from hard copies.
That's very helpful, as am I. Right, aggregation. Can I start, please, by taking the court to the policy, which is tab 13 in the core bundle. Tab 13, page 337, and one can pass over the first 3 pages and turn, please, to page 340. Where, just for completeness, I identify the insuring clause, which is obviously the start of everything, clause 1.1, civil liability. The insurance is against any claim, as defined by the policy, resulting in the civil liability where such claim arises from the insured's professional business. And there is then further wording which reflects the familiar fact that this policy is written on a claims-made basis. So there has to be either a claim made during the period of insurance or a notification of a possible claim made during that period. But no issue directly arises in this case on as to the meaning of that provision. Then, although I'm dealing with aggregation, I will just identify the fraud/dishonesty exclusion. That's at page 342, 2 pages on. (2.8). The heading, and there's no reason why that should not be material to the court's construction of this provision, is fraud or dishonesty. And then the clause provides as follows: any claims directly or indirectly arising out of or in any way involving dishonest or fraudulent acts, errors or omissions committed or condoned by the insured, brackets are excluded, close brackets, and then the important proviso, provided that, first, the policy shall nonetheless cover the civil liability of any innocent insured, and secondly, no dishonest or fraudulent act, error or omission shall be imputed to a body corporate unless it was committed or condoned by, in the case of a company, all directors of that company, or in the case of a LLP, all members of that LLP. This obviously will be debated as the appeal goes on, but there is a very obvious and critical distinction drawn by the wording of that clause between the commission of a fraud and the condonation of a fraud. And it is almost too obvious to be worth saying, but I will say it all the same, condonation is not the same as commission. And there are occasions, I will be suggesting, when the respondent's position comes close to saying that in order for somebody to have been found to have condoned a fraud, they must have as a partner in the relevant firm, so much knowledge of the facts of the fraud itself that they come very close to being, if they are not actually, a participant in the fraud. And that obviously is not the way this provision is intended to work. There is I will be developing this submission, there is an obvious and very substantial difference between commission of a fraud and condonation of fraud. But that is for later. Then, if I could take the court to the aggregation clause, please. That is page 349. Clause 5.2. One claim is the heading of the clause. All claims, and this mirrors the, as we will be discussing later, the dishonesty fraud provision does not precisely mirror the minimum terms, although I shall be suggesting it is in substance to the same effect. The wording of the aggregation provision does mirror the wording in the minimum terms. And it reads as follows. All claims against one or more insured arising from, and then there are 5 subclauses, will be regarded as one claim for the purposes of this policy and the payment of any excess. It is therefore, obviously, a deeming provision. It is a precondition to the application of the provision that there must be multiple claims. If you've only got one claim, you don't obviously need to aggregate. So that's a precondition. You don't get to aggregation until you have multiple claims. And the subclauses work as follows. Little a almost speaks for itself and is not material, one act or omission. Unsurprising if that generates more than one claim, it's unsurprising that would lead to aggregation. That's not what we're concerned with here. Little b, one matter or transaction. I shall explain the potential relevance of that provision in a moment. Little c, one series of related acts or omissions. That is a phrase which is very close to, effectively identical, as has been held recently, to the text in the provision which was considered by the House of Lords in the TSB case. So that one can, for ease of reference, one can refer to that simply as the TSB wording or the TSB subclause. I have decided very recently not to trouble the court with an argument that that subclause C, enables the insurer to aggregate in this case, because I have decided that the restrictive interpretation given to those words, or effectively to those words, by the House of Lords in the TSB case, which I will explain in a moment, is such that it is somewhere between very difficult and not possible to maintain an aggregation argument in relation to little c. So I have decided not to pursue that argument, which has always been very much a secondary or tertiary argument, alternative, and a secondary or alternative to our main contention in this area. Little d needn't take up time. It doesn't add anything to the analysis for present purposes. Little e is the critical provision. Little e says that an insurer can aggregate where all claims arise from similar acts or omissions in a series of related matters or transactions. I understand it to be common ground that the application of that subclause involves a two-stage test, a test with two limbs. It's obvious that it does. One has to ask oneself, first, are the acts or omissions which generate claim 1 similar to, not identical to, but similar to the acts or omissions which generate claim 2? That's stage, first limb. And then one has to ask oneself whether those acts or omissions have occurred in a series of related, that being the key word, related matters or transactions. That is the wording which was considered by all three courts, all the way up to the Supreme Court, in the AIG case, and that can be referred to conveniently as the AIG wording. And it is on that wording and the application of that wording and that test, those tests, that the parties will be focusing for the purposes of their submissions on aggregation. I just note, in case the court wishes to look at it at some point, that the definition of claim is at 8.5 and is to be found at page 354. But I don't want to take up time with that, which is peripheral to the central arguments. I would make this point before I go on to look at the AIG case and the TSB case and then the AIG case. The fact that an insurer is expressly entitled to aggregate where the multiple claims arise from one matter or transaction is significant. Now, we have submitted in our skeleton argument, we didn't below, but we have submitted in our skeleton argument, and in the grounds, we've mentioned it in the grounds of appeal, that the court could robustly dispose of the aggregation issue in this case on the basis that the so-called surplus funds claim and the dragonfly claim arose from the same matter or transaction, being the Taymouth Castle transaction, using that phrase broadly. That is a possible outcome. I don't resile from that, I don't withdraw that. My own friend says I may need permission to make that submission. I'll deal with that in reply if that point is maintained. But that's very much a secondary submission that I will be making. My primary submission is this, is obviously that subclause E fairly and squarely applies to the facts of the present case. The presence of subclause B, which entitles an insurer to aggregate where the claims arise out of one matter or transaction, is highly relevant in that it tells one that you only get to subclause E and the need to consider the possible application of subclause E if you are looking at two separate transactions, or I suppose two separate matters. If not, if the robust and practical assessment is that there is only one matter or transaction, then that's an end to the aggregation issue. The claims aggregate. So the debate about the application of subclause E must proceed, ought to proceed, on the basis that it is a given that there are two separate transactions. And when I come to criticise respectfully the learned judge's reasoning as to aggregation, I will be submitting that there are passages in that part of his judgment which do not entirely recognise the fact that the existence of two transactions is simply what one has to expect when one comes to consider issues about the application of subclause E. It is, as I say, a given.
Minimum of two.
I mean, yes. Yes.
Can I understand your robust argument that they arose, the surplus funds and the dragonfly frauds arose from the Taymouth transaction? Is that praying in aid then 5.2b?
Yes, it is. Yes, it is. And I described that.
Is that pleaded?
It's pleaded. It is pleaded. Wasn't run at trial for reasons that seemed good to me at the time. It is pleaded, and in short, my respectful submission is that there is no conceivable, as it were, evidential or other prejudice to the respondent if that point is taken now, because the issues which arise as to is this one matter or transaction are in substance the same issues as those which arise when one considers the question of relatedness between the first phase of the Tamar Castle dealings and the second phase. It's all the same area of inquiry. I describe it really against myself as a robust analysis of the situation, because I recognise that on the other side of the case, it can be said that there was the Tamar Castle purchase, which was completed in December 2018, subject to to a retention which had to be paid sometime later. There was that transaction. And then it can be said, and my learned friend does say this, there was a further fraud committed in January to March 2019, which involved the covert raising of money from the lender known as Dragonfly and the stealing of those monies. That's the counter-argument to the position I seek to take in relation to subclause B. But the court will see that one matter or transaction is a permissible assessment of this case. I will be submitting, I hope persuasively, that even if my own friend is right to say one really has to break this down into two stages and there were two transactions here, it is clear, I respectfully submit, I put it as high as that, it is clear, I would say completely clear, that subclause E is engaged here when one looks at the Woodman guidance, the AIG guidance, and when one considers the underlying facts. May I go then, please, to the first to the TSB case, which I want to consider quite briefly. There are two authorities bundled between those, and the TSB decision of the House of Lords is at tab 2, so volume 1, tab 2. As the court will recall, this was the case in which there were a very large number of so-called pensions mis-selling claims, and as it happened, the insurance policy provided for a very large deductible of £1 million, and each individual claim was worth a great deal less than that. Accordingly, in this particular case, it was the insured who was seeking to argue that the claims aggregated, and it was in the insurer's interests to show that the claims did not aggregate. So the position of insurer and insured were, as it were, the other way around to the position that the parties take in the present case. The wording of the provision which was considered in the House of Lords can be found at paragraph 12 of Lord Hoffman's judgment, which is at page 48, using the internal case imagination. Paragraph 12, page 48. The wording was as follows: if a series of third-party claims shall result from any single act or omission, brackets, or related series of acts or omissions, close brackets, then, reading on, or all such third-party claims shall be considered to be a single third-party claim for the purposes of the application of the deductible. The court, or Lord Hoffman, then went on, if one looks at the foot of the page, one moves down to paragraph 15, and then we're going to go over the page in a moment. Lord Hoffman considered some of the cases decided in the 1990s about aggregation and made some general observations about them, I think it's relevant just to show the court what is said on page 49, top half of page 49. Lord Hoffman there considers the AXA case, AXA and Field, the Cox and Bankside Members Agency case, and at little c, Lord Hoffman makes the point, or refers to another judge making the point, that where an aggregation clause uses the term originating, that can be taken, that should be read as opening up the widest possible search for a unifying factor. And that reflects what is, I'm sure, common ground between us and clear in this area, that the widest type of aggregation clause is one that uses a concept such as originating cause. Now, the negotiations between the insurance market and the regulator have not led to that provision being used in the minimum terms. And that's not surprising, because if the aggregation clause in the solicitor's policy contained wording using the concept of originating cause, then that would be a very wide aggregation policy, which would, for instance, in this case, probably enable the insurer to aggregate all claims arising out of the dishonesty of Mr. Jones, certainly pertaining to client money, irrespective of the identity of the clients who were defrauded, or even perhaps the dates on which the frauds were committed. And if wording of that nature had been used in what I referred to as the Bishop of Leeds case, then it would have been probably open to the insurer to aggregate in that case in relation to all the frauds committed by Mrs. Box over time, because all the claims ultimately, or all the claims originated as a matter of causation from her dishonest practice of stealing client money. But that's not the wording that's used in the minimum terms, not the wording we're considering here, and I make that point as it were against myself. I entirely accept that this aggregation clause does not use the widest possible wording that opens up the widest possible search for a unifying factor. At paragraph 17, Lord Hoffman goes on to say this: the choice of language by which the parties designate the unifying factor in an aggregation clause is thus of critical importance and can be expected to be the subject of careful negotiation. And then his lordship cites Lord Mustill, who said in the AXA case that among players in the reinsurance market, keen interest is shown in the techniques of limits, layers, and aggregations. I'm sure that's right. The decision, to take this very shortly, but the decision in ratio of this case can be found, in substance, can be found in paragraph 27 on page 51. At the top of the page, a few lines down, little b, having discussed upstream and downstream causation, Lord Hoffman says this, little b, this obviously does not mean that it is enough that one actually resulted in one claim and another act in another claim. That provides no common causal relationship. It can only mean that the acts or events form a related series if they together resulted in each of the claims. And that is the ratio TSB. And it is that which, as we'll see in a moment, the insurance market regarded as a very disappointing outcome, although the insurer in question was very happy with this decision, because they regarded it as a surprisingly restrictive interpretation of the words that had been used. Lord Hobhouse, that there's a subtle difference of approach taken in the speech of Lord Hobhouse, but I don't think that it is relevant to consider that for the purposes of the present argument.
So just looking at your grounds of appeal, ground 12, you rely upon 5.2e, and then alternatively 5.2b or 5.2c.
My Lord, yes.
So we can cross out C.
Strike through C, my Lord, yes.
But you maintain B.
I maintain B, so, and I'll deal with the submissions my Lord will make about that in due course. But I maintain B, but strike through C. Thank you.
But that's a mere assertion at the end there, because the reason grounds at 10 and 11 don't relate to B, do they?
No. 10 and 11, and this perhaps reflects the central gist of my submission on aggregation. 10 and 11 certainly relate to E.
E. Yes.
To E, yes.
So 12 relying on 5.2b is A, new, and B, unreasoned.
It's pleaded, but it's new so far as the litigation is concerned, and it's unreasoned in the grounds of appeal.
Yes.
I accept that.
Yes.
Accept all those things. Well, for the court to make a finding in my favour on B, what would have to happen, maybe quite a remote contingency, is that the court would hear the submissions, which it certainly will hear, about the relatedness, the relation between the matter or transaction which generated what's called the Dragonfly claim. Hear the submissions about the relation between that and the earlier claim, relation between those two things, and would, as I say, robustly conclude that one doesn't even get to E, because it's proper to regard the whole thing as one matter or transaction. And I have made it clear that I accept that would be a robust conclusion. I wish to leave it open to the court, but I put it no higher than that. As your Lordship will be seeing, the gravamen of my submission is that we are squarely within little E. Can I
just to understand in plainly, one can define transaction, matter or transaction, in a number of different ways, and you can take it to different levels of abstraction.
Yes.
And in a sense, it may be that dealing with Taymouth Castle would be one client file, as it were, possibly.
Indeed.
But the transactions I'd have thought you're looking at must be solicitor transactions that you're looking at. What are the transactions the solicitors are undertaking? And on the face of it, these two transactions, 10 months apart, were distinct transactions, were they not?
Well, the purchase of the castle ran from March 18 to December 18. It was completed in December 18, although it's true that the monies were abstracted dishonestly in March 2018.
Yes.
April. I'm sorry, not March. April. And the theft of the Dragonfly monies, or part of those monies, occurred between January and March 2019. Yes. And indeed, it is it is that analysis which caused us to take the approach that we took in first instance. And as I say, I've as Lordship could tell, I'm rather tentatively advancing the subclause B analysis as an alternative.
No, but you are advancing it.
It's there, my Lord.
Well, you are advancing.
I may take stock at 1 o'clock, but it's there. The thrust of my submission, which I'm developing, is that B is an important part of the overall analysis of the situation, but we are squarely within E, which I hope to demonstrate. May I now show the court the authority which needs to be added to the authorities bundle? I think it's reached the court by email, but I have copies here which I would like to pass up if I can. ask somebody behind me to assist. I'll do it myself. Thank you. This is the Court of Appeal decision in the AIG case, and it would probably make sense to put it, if the Court would, at the back of tab 6, which presently contains the first instance decision of Mr. Justice Tier. This claim, or this set of claims, as the court will know, involved two developments, one in Morocco and one in Turkey. There were many different individual investors who were claimants. There was one defendant firm of solicitors. There was a deed of trust in relation to each site, which was designed to act as operator's security or providing security in relation to the monies invested. The investors were beneficiaries under that trust, and the solicitor in some way acted as an escrow agent. The gist of the complaint against the solicitor was that invested money was released when it should not have been released, with the consequence that the investors suffered loss. And the issue that arose was whether all these claims could be aggregated by the insurer, or alternatively whether some of the claims could be aggregated with other claims, even if it was not possible to aggregate the totality of the claims. I won't take up time with the first instance decision of Mr. Justice Tier. I will simply mention that decision. The learned judge held that the claims did not aggregate. He accepted that the relevant acts or omissions were similar. So the first limb of the aggregation provision was satisfied. But he held that the transactions, the underlying transactions involving the many investors, were not related on the basis that the correct construction of the provision required, for the transactions to be related, required that they had to be dependent on each other. So that was the key word in terms of the analysis at first instance: dependent. The Court of Appeal, which was in turn reversed by the Supreme Court, disagreed with Mr. Justice Tier. They held that requiring dependence between the transactions was something which had not been expressly stipulated by the contractual term and was too restrictive. However, that court construed the term on the basis that there was a different requirement that had to be shown in order to establish the necessary relation, and that was that the relationship had to be intrinsic, or had to involve some sort of intrinsic factor.
Well, is it intrinsic rather than remote relationship?
Yes, intrinsic relationship, yes. And one, if that remained the law, then one would have to spend some time working out precisely what that word in this context means. But however, as the court knows, as I've said, the Court of Appeal's decision has been reversed by the Supreme Court, essentially on the basis that the requirement that there be some intrinsic quality to the relationship is not provided for by the term, and added an unnecessary and unnecessary gloss that was rather hard to understand and to apply. The main reason why I've brought the Court of Appeal decision to the attention of this court is that it contains, of the cases in the line of cases in this litigation, line of judgments in this litigation, it contains the fullest and most helpful description of what occurred after the House of Lords had given judgment in the TSB case. There was a significant reaction, which it has been held, certainly in this judgment, it has been held, it is relevant to, as part of the matrix to the construction of the provision which is being considered in this court. One finds the material that is of assistance in that respect at internal page 295. Beginning internal page 295, beginning at paragraph 28 at the foot of the right-hand column. Lord Justice Longmore said this: "No doubt the insurers were pleased with their victory in the Lloyd's TSB case, for the reasons I've explained, but it seems to have caused consternation to the professional indemnity insurers of solicitors, in which aggregation clauses apply not so much to deductibles where the insured would wish to aggregate, but to any limit of liability of the insurers under the policy where it would be the insurers who would wish to aggregate claims in order to rely on the overall limit in the policy." Then his lordship goes on to, reading over the page, to set out the very short aggregation provision which existed when the Solicitors Indemnity Fund was providing insurance to the profession. At that point, it consisted simply of a provision stating that all claims arising from the same act or omission shall be regarded as one claim. The fund ceased to provide insurance at the end of the last century, and in September 2000, solicitors had to go to qualifying insurers in the commercial market, which led, as the court knows, to the preparation of the minimum terms and conditions. And the new provision in 2000 contained wording, I won't read it out because the court now has the point, but it contained wording about 6 lines from the top of page 296, left-hand column, which is very similar to the wording considered by the House of Lords in the TSB case. And his lordship makes that point in the next paragraph. Then, at paragraph 29, we are told this: "The Law Society Gazette for 27th of January 2005 takes up the tale." And then reading down about 8 lines, one sees this: "The qualifying insurers had assumed that the wording of clause 2.5 would enable them to treat as one claim multiple claims arising not only from a series of related acts, but also from a series of similar acts. The decision in TSB has established that the qualifying insurer's assumption was wrong." Then reading down 3 lines, "The qualifying insurers are seriously concerned that the decision in the Lloyd's TSB case has narrowed the effect of the aggregation clause in the minimum terms to an unacceptable extent. They sought an amendment of clause 2.5 to put them back in the position they thought they were in before the Lloyd's TSB case. Qualifying insurers maintain that if some action is not taken to mitigate their exposure, there will inevitably be some disruption in the marketplace in relation to firms' ability to obtain insurance at an affordable cost." The reworded definition, as agreed between insurers and law societies, then set out, and that is in substance the wording that we are considering in this case. Right-hand column, a few lines down, "The new wording ostensibly provides greater scope for aggregation of claims." And then it's explained that the Counsel of the Law Society took advice from certain advisors, including external indemnity insurance advisors, to the effect that, quote, this issue was of sufficient concern to qualifying insurers that there was a risk that a number of insurers would withdraw from the market for solicitors' compulsory indemnity insurance, precipitating an increase in premium rates. And then the article in the Law Society Gazette goes on to discuss increases in the minimum sum that has to be insured and so forth. I needn't take up time with that. And may I ask the court to turn to page 297. Paragraph 30, left-hand column. This published history of the origin of the clause is, in our judgment, part of what has come to be called the matrix against which the clause has to be construed, and is a legitimate aid to construction, although not put before the judge. Both parties wish to rely on it in this court, and then I summarise why that was, or how that came about. The insurer, AIG in that case, my client in this case, took the obvious point that the change to the aggregation provision in 2005 was clearly designed to widen the scope of the aggregation provision as compared with the scope of the provision that was before the House of Lords in the TSB case and was construed restrictively in that case. That's apparent, and that is a legitimate aid to construction. Perfectly fair point can be taken on the other side of the argument. It was taken in the AIG case, and it can be taken here, which is that it's obvious that the aggregation clause has not been widened as extensively as it could have been, because it doesn't contain originating cause wording or anything of that nature. So that's the potential relevance in my submission of the negotiated change to the aggregation provision that occurred in 2005. And the new wording, much arbitrated I expect, but did not come before the court until the AIG case, to which I now turn. We're in the AIG case, before the court in this case. It was concluded, resolved by the Supreme Court in the decision which is at tab 9. I don't think I need to take up time with the head note. I've explained the underlying facts. I can go straight to paragraph 14 of Lord Toulson's judgment. Read down 6 lines or so to little f. Lord Toulson said this: there is a further reason for adopting a neutral approach in the interpretation of the minimum terms. The Law Society is not in a position comparable to an insurer proffering an insurance policy. It is a regulator setting the minimum terms of cover which firms of solicitors must maintain. In doing so, it has to balance the need for reasonable protection of the public with considerations of the cost and availability of obtaining professional indemnity insurance. Those are the two countervailing considerations that the regulator and, for that matter, the market have to take into account. And it will be obvious to the court that they are indeed countervailing considerations in this sense. It is certainly a desirable objective that those who use the services of solicitors who have been let down by solicitors should be compensated where that is feasible. That is obviously a desirable objective, and that objective is reflected in certain aspects of the minimum terms. So that is certainly a material consideration. But on the other side of the analysis, it is also a very desirable objective that proper insurance should be obtainable from the commercial market at premiums and at premiums that are not unreasonable and are affordable. And nothing is free in life. Of course, if the premiums are too high, then the costs have to be passed to those who use the services of solicitors, and they are disadvantaged in that way. So a balance has to be struck. Therefore, the court should not and does not approach the construction of these provisions in a way that involves a starting point of supposing that using some sort of presumption that a construction must be favoured because it will lead to claimants being compensated. That isn't a presumption, nor is there a presumption operating in the other direction. A neutral starting point is appropriate, and Lord Toulson holds that is so in that paragraph. My learned friend may accept that analysis. I, for the moment, treat it as common ground by reference to paragraph 87, his main skeleton, but we will see if he develops any submission that qualifies what is said there. I then complete my consideration of Lord Toulson's judgment and the Supreme Court decision by taking the court first to paragraph 18, please, paragraph 18 on the next page, 1174. Paragraph 17, Lord Toulson has referred to the important limitation that the setting of the acts or omissions giving rise to the claims was a series of related matters or transactions. And then his lordship goes on to say this: looking at the matter broadly, it is easy to see the reason for such a limitation. If insurers were permitted to aggregate all claims arising from repeated similar negligent acts or omissions arising in different settings, the scope for aggregation would be so wide as to be almost limitless. By requiring that the acts or omissions should have been in a series of related transactions, the scope for aggregation is confined to circumstances in which there is a real connection between the transactions in which they occurred, rather than merely a similarity in the type of act or omission. So, taking stock there, one finds that the test is, this exercise requires one to look for, quotes, a real connection between the transactions. His lordship then goes on to criticise and reject the Court of Appeal's use of the word intrinsic. He didn't take up time with that. I can move on, if I may, to the foot of the page, paragraph 22. Subclause little 4, that's the same as little e, separates the requirement that the acts or omissions giving rise to the claims should be similar, and the requirement that they were in a series of matters or transactions which were related. Each limb must be satisfied for the subclause to apply. Use of the word related implies that there must be some interconnection between the matters or transactions, or, in other words, that they must in some way fit together. But the Law Society saw fit, after market negotiation, not to circumscribe the phrase a series of related matters or transactions by any particular criterion or set of criteria. The absence of further prescription is not particularly surprising, considering the very wide range of transactions which may involve solicitors providing professional services. Determining whether transactions are related is therefore an acutely fact-sensitive exercise. And then his lordship cites a dictum of Lord Justice Ricks, namely that it involves an exercise of judgment, not a reformulation of the clause to be construed and applied. And then it's helpful to see how Lord Toulson applied those observations or determinations to the facts that were before the court, the assumed facts that were before the court. One looks down to the foot of the page, paragraph 26. Viewed objectively, the connecting factors identified above drive me to the firm conclusion that the claims of each group of investors arise from acts or omissions in a series of related transactions. The transactions fitted together in that they shared the common underlying objective of the execution of a particular development project. And they also fitted together legally through the trusts under which the investors were co-beneficiaries. So there, Lord Toulson is expressing a firm conclusion that the claims of multiple investors in relation to either one of the two developments would fall to be aggregated with all the other claims that related to that development. So all the Turkish claims go in one aggregated pot, and all the Moroccan claims also go in a different aggregated pot. The two pots were different, as one sees from paragraph 27. The case for aggregating the claims of the Peninsula Village investors in Turkey with those of the Marrakesh investors is much weaker. They bear a striking similarity. That is not enough. I see the time, my lord. That would be a convenient point at which to take a short break.
We finished with this, the Supreme Court decision, have we?
Yes, we have it.
Very well, thank you. Well, we'll have a 5-minute break.
know it's going to take longer than I can't expect. Yeah. And there would have been, of course, there would have been temporal.
Are we ready to start?
Yes, thank you.
Yes. So it's just taking stock
Yes.
of where we are.
Yes.
Obviously, this is your alternative argument.
Yes.
It only arises if you're wrong in your first
Indeed.
argument. And you have very helpfully but quite painstakingly taken us to the point of what the applicable principle is.
Yes.
But as the Supreme Court says, at the end of the day, it's an intensely fact-sensitive issue.
Yes.
I think we just feel maybe that
Let's get our
there's
teeth.
only so long we can spend dancing around the
Indeed.
the issue.
Indeed.
So just some guidance.
Indeed. No, that's very helpful, my lord. I had I'm keeping at least one eye on the clock, and I'm conscious that I took a little time laying the case law, as it were, foundations before the court. I thought it might be, hoped it would be helpful to do so. But I'm now going to move on and make what's quite a short submission about, first of all, about the facts of the case, and then a short submission as to why it is, I say, that the learned judge got this wrong, and as to certain deficiencies in the relevant part of the judgment. Before I finally leave AIG and leave the case law, may I just make this broad submission? It is that the facts of the present case are, if you like, a fortiori, the facts of the AIG case, certainly in one critical respect. Lord Toulson was considering multiple claims that have been brought by multiple different independent investors. No doubt the investments had also been made at different times as the investors were lured into the Turkish and Moroccan developments. So there was not a one claimant or one investor link or unifying factor or relation in the AIG case, but nonetheless the court held that the claims aggregated where they related to one development. The present case is a fortiori because it is in substance a one claimant or one purchaser or one investor case, and I shall demonstrate to the court that the three companies who are claimants herein are essentially members of the same group and sufficiently closely connected to form one economic unit. So the present case is a fortiori because it not only involves in substance, in economic substance, one claimant, it also involves one development. This was a development, it was a purchase and a development. So for that essential reason, I do make the submission that the AIG decision in the Supreme Court is very strongly, it provides very strong support to our arguments on the second limb of the aggregation, relevant aggregation provision. Of course, I'm going to need to deal also with the first limb, which concerns acts or omissions. Well, can I then move away from the authorities and try to look at relevant aspects of the evidence about the facts of the course of dealings, to call it that. There is a helpful document in this respect, which is the claimant's own pleading, particulars of claim, that they served on the Jirehouse defendants and others in proceedings before they, in which they obtained summary judgment, or default judgment, before they went after the insurers. That is at Supplemental Bundle 2, Volume 2, Tab 60. And if I could turn to the first page of the amended particulars of claim, which is 255. Paragraphs 1 to 2A identify the three claimants, or the three claimants herein. The company at the head of the group, or this part of the group, is Discovery Land Company, referred to as DLC. That's referred to paragraph 1. The second claimant is a Delaware company, which was used by DLC to acquire Taymouth Castle. so acting on behalf of DLC for that purpose. And the third claimant, the River Tay Castle LLP, is a LLP ultimately owned by TCD and therefore ultimately owned or controlled by DLC. So I hope that, I don't understand this to be contentious, I hope that makes good my submission. This was essentially one economic unit. Then if I could just take the court at speed through this document to identify the way in which the dealings progressed. Could I go to page 257? Paragraph 12. On or around 16th of April 2018, the parties agreed to a purchase price of 9.62 million, and one of the claimants wired just over $14 million to Jirehouse in 2 tranches. So that's what happened in April 2018. That was, it is true, quite a long time. Well, it's relevant to note that was quite a long time before the purchase actually completed. Then on the same page, if one looks at paragraph 15, one sees that Mr. Jones recommended that the purchase of the property should take place through a special purpose vehicle, namely EAML. That was one of the Esqueline companies. And its use was recommended by Jirehouse in order to provide anonymity as the identity of the purchaser. And elsewhere in this pleading, and there's nothing sinister about that in itself, elsewhere in this pleading, it is explained on behalf of the claimants that because of previous dealings between an individual who stands behind the claimant companies and the seller of the castle, it was thought desirable to have a so-called front-facing purchaser who appeared to be nothing to do with the relevant individual, so that the earlier negotiations at a higher price did not prejudice the acquisition of the castle. That was why it was structured in this way. Then if we turn on 2 pages to paragraph 259, please. Paragraph 23, we find that 2 further payments were made, amounting to $2 million on the 14th of November 2018. And then what then happened, as the court will have picked up, is that Mr. Jones, undoubtedly dishonestly, in early December informed his clients that he needed more money because the initial funds had been effectively frozen as a result of money laundering issues. And that led, if one goes to page 260, that led to a further payment being made to Jirehouse on the paragraph 27, a payment of $9.3 million on the 7th of December 2018. So the money, which because of Mr. Jones's manoeuvre in total greatly exceeded that which was required to purchase the castle, was paid essentially in 3 stages: April, November and December 2018. Then if one turns to, stays on that page, I just note paragraph 31. The transaction was structured in undoubtedly a complex way. Paragraph 31 refers to a loan facility agreement which was made between the Esqueline company, EAML, which was a Jones entity, and DLC, and the pleading goes on to explain that that contained terms which contemplated a subsale arrangement which would lead to one of the claimant companies eventually acquiring the castle in its name. I needn't take up time with the details of that. If I can turn to page 262, paragraph 43. That tells us that completion occurred on the 7th of December 2018. And so while it is true that the initial monies that were misappropriated by Mr. Jones were paid to Jirehouse in April 2018, the transaction itself did not complete until December 2018, which I would submit, was shortly before, manifestly it was shortly before the further theft which was about to occur.
When was the first theft?
The first theft, the monies were paid in April 2018 and removed in 2018, in April 2018 on the evidence. So
Right.
the monies were stolen then, but
Where do we see that in the pleading?
we don't, but that's common ground between the parties and was common ground below.
But there must be an allegation that they were stolen.
It's certainly that allegation is coming. I think at this stage, the claimants would not have known when the monies had been stolen. Their case simply was that the monies had been paid. You held a lot of money for us, you haven't paid it back.
Well, they'd overpaid, hadn't they? They'd been told that more money was required, and that was untrue.
Exactly, they knew that, and they'd also discovered that the Dragonfly loan and charge had been taken out and charge had been executed, which obviously was of concern to them. The pleading then goes on, just so the court can follow this through. One goes to page 264. Paragraph 50 summarises the cumulative effect of the fairly complex sequence of transactions that are set out in this document. And the court will see what is said there. RTC became the owner of the property. It had certain internal corporate liabilities to its associated company, but Jirehouse was responsible, bound by its undertaking to repay $9.3 million as stated, and certain surplus funds were held on trust by Jirehouse, or should have been. Then the pleading at paragraph 51 and thereafter describes a remarkable and disgraceful sequence of events and communications between December 2018 and late February, early March 2019, in which Mr. Jones wrote a string of highly legalistic and, one has to say, ingenious emails in which he tried to fob off his client on the basis that money laundering problems were making it impossible for him to return the money which they were seeking. And indeed, at one point, he made a suspicious activity report to the NCA. We might this afternoon, if we have time, look at one or two documents from that period. Meanwhile, one can then go on to page 265. He was obtaining more money that he intended to steal. At the foot of page 265, paragraph 59A, on or around 21st of January 2019, so a few weeks after completion, Mr. Clark, reportedly in his capacity as a director of another company called Taymouth Member Number 2 Limited, which was set up as one of the designated members of the third claimant, RTC, Riverdale Castle LLP, signed a loan facility agreement with, among others, the company known as Dragonfly, which provided for a secured loan of, in round figures, £5 million.
Now, pausing there, that's got nothing whatsoever to do with the sale and purchase of the property, has it?
It has quite a lot to do, or potentially, as I shall demonstrate, my lady, had quite a lot to do with the overall transaction, which involved an intention to develop the property. What I'm going to show the court briefly in a moment is that the possibility of raising further money on the security of the property had been contemplated for a long time in 2018 by the client as well as by the dishonest solicitor. The intention was to raise further money as project finance to, no doubt, to support the development of the property, and there were various negotiations and dealings in relation to the possibility of taking out a borrowing in this way.
Yes,
So,
but what you've got is DLC and associated entities as a first stage towards a future plan to develop the property if it's acquired, engaging Jirehouse to act as its solicitor for the purpose of acquiring the property. And in the course of that property acquisition, Mr. Jones snaffles the money. That's nothing to do with any wrongdoing by Mr. Jones and his cohort of accomplices in relation to later loans on the strength of the property once acquired.
Well, when relation says nothing to do, I respectfully would not agree at all with that formulation.
Well, I know you wouldn't because it's not your case, but...
And the reason why I respectfully submit that the court should not ultimately take that view of the matter, or among the reasons that I make that submission, are the following considerations. First, as I will demonstrate, the further fraud in January 2019 was in part, it seems, needed in order to satisfy an obligation that remained in relation, continued to exist in relation to the acquisition of the castle, namely the payment of the retention monies, which was no longer possible from monies held because the monies held had been dissipated. So the further loan had to be taken out for that reason, it seems, and was used for that purpose, as I shall demonstrate. So that was one direct connection between the further theft and the original transaction. But in any event, I respectfully submit that one needs to be cautious about phrases such as nothing to do with. What I need to show for the purposes of this argument on aggregation is that in some way the matters or transactions fitted together.
That's exactly what the judge said. He said at paragraph 158 of his judgment that they did not fit together.
Yes.
So in a sense, he made the evaluation in the highly fact-sensitive analysis, and you're disagreeing with his conclusion.
I am. This particular finding that the learned judge made is an evaluative finding which does not rest on any determination of primary fact that involved his consideration of oral evidence or anything of that nature. I do submit that it's an evaluation that this court is just as well placed to carry out as the judge at first instance. And I will submit in a moment when I get to the text of the judgment that there are certain problems and deficiencies with the learned judge's treatment of this point. He takes it very shortly, and I'm going to identify. I'm going to attempt to identify certain gaps in his logic and in his reasoning. But coming back to my lady's point, we know from AIG that in order to establish a real connection or the appropriate relatedness between the two matters or transactions, I do not need to show that, in some sense, the second was dependent on the first, or the first was dependent on the second. That was the misconception that the Mr. Justice Tier made at first instance in AIG, which was reversed in the Court of Appeal. Nor do I need to establish any intrinsic quality to the relationship. That misconception has been dispelled by the Supreme Court. I just need to show that there was a real connection and that in some way the things fitted together. And here we have, as in AIG, we have one property. Mr. Jones couldn't have got his hands on the extra £5 million were it not for the earlier transaction involving Taymouth Castle, because he was only able to get his hands on that money because the earlier transaction had been structured so that a company which he controlled was a designated member of the third claimant, and was therefore able to cause the third claimant to grant the charge which led to the money being advanced. So while I don't have to show dependence, I certainly can show that the way in which the purchase transaction was structured enabled the further theft to be committed weeks after the completion of the purchase.
I mean, these are the points. You're now repeating really the arguments which the judge summarises at 159 of his judgment.
To an extent, and they were, in my submission, good arguments which the court should have accepted, but I am to an extent, yes.
Yeah.
Can I just, I think I can, yes, I can invite the court to put to one side for the moment SB2. I'm not going to go back to the claimant's particulars of claim. I hope that document, which obviously sets out the claimant's own position, is a helpful guide to the course that the transaction took. Can I, before looking at the judgment, identify two further matters which are relevant to the, I do submit, really quite strong connection, real and strong connection between the two transactions or matters, if they are to be so regarded. First, could I'll just note for the transcript that our argument on this is at paragraph 109 in our skeleton at 3/62, but I'm obviously not going to weary the court by repeating orally what is in the skeleton. That's where the written argument is to be found. May I go to the unagreed but now admitted bundle of documents, which is we can refer to as the unagreed bundle for convenience. My unagreed bundle, not my learned friends. May I go to that, please? Can I take the court first to a letter from my learned friends instructing solicitors in which certain important concessions were helpfully made for the purposes of reducing the documents that the court had to be shown. That letter is at tab 26, back of the file, tab 26. It's, is it 26? 27. My tab numbering is awry, I'm afraid. Tab 27. And it's a letter dated the 6th of November 2023. And I can go straight to page 203. At the bottom of page 203, the court will see this, little b. Our clients do not dispute that. First, from July 2018 to October 2018, Mr. Jones was suggesting security over the castle, purportedly to protect our clients from an alleged transaction at undervalue issue. Loan application was made to Together Finance in November 2018 with a subsequent application to Octopus. I interpose that is understood with the same company as Dragonfly, and then to Dragonfly, as set out in passages in our skeleton argument. Then it is said our clients did not in fact authorise such applications, and we're not aware of them at any material time. Well, I'll just take the court to a document that bears on that. Second concession, the castle was purchased using DLC's money, with EAML acting as a front-facing buyer and JTL, another Jirehouse company, acting as escrow agent holding the retention to be paid to the vendor. Third concession, an important one, Mr. Jones procured the Dragonfly loan, most of which was misappropriated. but part of which was set aside for the retention money which was due to be paid in March 2019. So those are all, in my respectful submission, factors which link what I would characterise as stage 1 and stage 2, but which clearly link what was going on in relation to the purchase transaction which did complete in December 2018 and the further fraud which involved charging the castle and stealing some part of £5 million and using the rest of it for the purposes of the post-completion matters that I've mentioned in the early part of 2019. I respectfully submit that if one is looking only for a real connection, stripped of any glosses to intrinsic matters or dependency, one's simply looking for a real connection, a certain degree of fit, there clearly are those things. The two matters were closely linked, and I come back to the important point that Mr. Jones could only have got his hands on the further £5 million because he was able to cause one of the claimant companies to charge the castle, and he was only able to do that because of the way in which the purchase itself had been structured. So I respectfully submit that if, as is the case, one is only looking for some sort of real connection for this aggregation provision to be engaged, one certainly got it here. And if this...
Can I understand
Yes.
When we saw the pleading in the Jirehouse claim, there's the references to Mr. Clark purporting to act as a director. I'm afraid I haven't gathered who Mr. Clark was or what his role was.
He was a long-standing connection of Mr. Jones, who acted as director of a number of the companies which Mr. Jones used, or to some extent controlled, perhaps owned, in connection with his various activities, some of which we'll be looking at when we come to.
So he was, as it were, in Mr. Jones's camp. He was a stooge or a conspirator or a nominee or however.
He was somewhere between a stooge or a nominee. He was very firmly a Jones man.
So he had procured that. He had suggested or procured that Mr. Clark was appointed a director.
Yes, well, it was the entity which was a member of the third claimant, which was itself an LLP, was a limited company, named in the pleading we looked at. I forget its precise name. And Mr. Clark was a director of that limited company and was therefore able to cause that limited company to do things as a member of the third claimant, which is a LLP, which led to the creation of what the lender regarded as an effective charge. That's how it worked.
So the suggestion what you're saying is that the structure which Mr. Jones put in place following the purchase was then used by him to facilitate this further fraud.
Necessarily prior to the purchase, because what enabled him to effect the fraud using the agency of Mr. Clark was the, if you like, the corporate or the LLP structure, which had been put in place, which concerned the third claimant, which was the ultimate designated purchaser. And Mr. Jones put it all together in a way that provided for certainly one member of the third claimant LLP to be a company that was under his control via Mr. Clark. Yes, there is a, in the unagreed bundle, I need to open it up, but Mr. Clark is described in these terms. Mr. John Clark, it's page 158, transcript, page 158, tab 25 of the unagreed bundle. Mr. John Clark acted as director from 2010 to 2019 of a company called Jirehouse Capital Finance. Both Mr. Clark and another person appear to have been associated with Mr. Jones. They were both directors of a large number of companies associated with Mr. Jones and Jirehouse. So he cropped up on the fringes of the case, and he was very definitely a Jones man, or possibly even a Jones stew. The other specific document that if I may like to draw to the court's attention, relating to the linkage between the £5 million Dragonfly fraud in January 19 and thereafter, and earlier dealings, is in the unagreed bundle at tab 17. At tab 17, thank you. Tab 17 of the unagreed bundle. What the court is looking at here is a chain of emails, and one needs in fact one should go to the last page in this tab, which is page 82, tab 17, page 82. There, it begins at the bottom of page 81. One has an email from Ms. Toteava, who is a Jirehouse employee, to Kevin Hinkle, who is a representative of the first claimant, copy to Mr. Jones, setting out the details of a loan offer made by Octopus, which I think was broadly the same as Dragonfly, and the court will see that was a loan for £5 million on certain terms. On page 81, Mr. Hinkle of the first claimant replied, saying, I thought they were not looking to attach to the underlying property, and so on, expressing the view that it puts the claimants further at risk, and raising various queries about the interest rate and so forth. Page 80, there's an email back from Mr. Jones on January the 6th, 2019, seeking to answer Mr. Hinkle's queries. The court will see broadly what is said there. The details, I think matter not. And then at the top of the page, Mr. Hinkle responds to that. Doesn't respond to that. He emails various other people connected to the claimant companies about the proposal that money should be borrowed from Octopus. He says a couple of options have been offered. The first involves a project loan with Dragonfly Capital Octopus Property, which provides bridge financing for projects such as Taymouth. Jirehouse has arranged a £5 million facility which can be funded as early as this Friday. While I do believe some project debt is good for the project, according to Henry, it's Mr. Anderson, this group is a little predatory, and so on. Then a few lines down, one sees also this. The other potential source of funds would come from a separate Jirehouse fund. I'm not 100% clear on how this would be structured yet, and I've asked for additional information, but I'm sure they will want some kind of loan terms to be executed, which again feels like could overcomplicate an already complicated structure. I do respectfully submit that one gets on this side of the court, I get a lot of assistance from material of this nature. There are other emails about the discussions about a possible loan. Mr. Hinkle in that email clearly regards the taking out of a secured loan for the purposes of project finance as part of the overall structure pertaining to the purchase and development of Taymouth Castle. It's a complicated structure. It will be overcomplicated perhaps by the taking out of a loan, but the point stands. Taking out the loan
I don't read that way at all, with respect. He's looking at the potential for bridging finance for a development, having acquired the property. What he most certainly isn't doing is looking at a potential for bridging finance to be used to repay or pay retained funds to the person who sold him the property in the first place, which is what Mr. James was doing behind everybody's back.
My lady, I wholly accept that. What Mr. Hinkle was contemplating there was not, could never be, that which Mr. Jones apparently was plotting to do and that which Mr. Jones did do, because what Mr. Jones was planning to do was fraudulent, was not known to the claimants. He was going to raise £5 million in very much the way that Mr. Hinkle was contemplating, but not for the purposes of project finance. He was arranging it so that he could steal the money and use part of it to meet an unsatisfied obligation relating to the purchase agreement, which couldn't be satisfied from the original funds because he'd stolen the original funds. So I don't seek to quibble at all with your ladyship's point that what Mr. Hinkle had in mind was certainly not what occurred and not what Mr. Jones was dishonestly planning to do.
When you're looking at transactions, you see, I think there seems to be a blurring of the lines with respect between looking at the transactions which were authorised and agreed transactions and looking at what Mr. James was up to behind the scenes. Because you made the submission to us that the purchase of the property facilitated Mr. James behaving in this dishonest way. Well, undoubtedly it did, but that doesn't make the transactions related. It simply shows that transaction A enabled him to put him in a position to be able to steal the money. One has to say that it was contemplated that there was one overall project which involved purchasing the property and then borrowing finance in order to carry out a development.
Well, that was the case, and this email, I do submit, reflects that was the case. I mean,
well, at the moment, there's no suggestion that project debt was in any way contemplated at any stage until this all came on the scene in 2019. Or was suggested by Mr. James and his merry men in July 2018, according to the concession.
Well, that's right, lady. There were considerations given between, maybe even earlier than July 2018, but it matters not, between summer 2018 and the end of 2018, consideration was given to taking out secure borrowing on this property, partly to deal with a possible issue about transactions at an undervalue, but as this January 2019 email tells us, certainly, partly, with a view to raising what is called project finance. If you buy a Scottish castle, no doubt it's falling down to some extent, and you may need project finance to do what you wish to do, to develop the property. And that's what the claimants were considering. So, while I don't have to show that the one thing was dependent on the other, although I can make the point, and do make the point I've made about what it was that enabled Mr. Jones to carry out the fraud. All I'm seeking to show is some sort of fit, some sort of relation. And relation, I expect to submit, there certainly was. One property, one victim, one fraudster, and a number of linking factors between the taking out of the loan in January 2019 and the purchase transaction, which had completed subject to payment of the retention needed to be filed in December 2018. So I urge as vigorously as I'm able to do that constitutes a real connection and two matters that in certain ways fit together very clearly. And I of course have the point that in this case there is an additional feature which was not present in AIG, which is that there was only one victim.
You keep saying there was only one victim. That ignores the fiction of corporate personality. It ignores the fact that there's an LLP involved. You can say that they're part of the same group. They're not actually one economic unit, and they're not one victim.
Well,
you've got three victims.
In terms of strict application of the theory of corporate personality, yes, you do. There are three separate corporate entities.
And it's also wrong to say that the LLP is the same economic unit as the parent company.
They are one economic unit in the sense that they are working together. They are ultimately funded from the same source or sources. One can tell from the pleading that I went to earlier that the funding came partly from the Discovery Company, which was controlled by Mr. Meldman, and partly from an American investor called Mr. DeGioia, who was the individual who was originally interested in the castle at a higher price and whose involvement had to be concealed. So the funding came from those sources working together. And they chose to structure the transaction using three different corporate entities, treating an LLP as in one sense a corporate entity. But in my respectful submission, none of that matters at all. Here we are dealing with an aggregation provision which been negotiated in the circumstances that I've identified and which is designed to enable insurers to achieve a degree of protection in certain defined circumstances. Important part of the overall structure of this this section of the insurance market. And when this court comes to resolve this issue, my respectful submission is that this court must look at substance, not form. The fact that there happen to be three different corporate entities involved on the claimant side is my very respectful submission, not material here. One looks at the underlying economic interests and one says, are we in reality dealing here with one victim or three, or as in the AIG case, hundreds?
You can see in that case, in some ways, one can slice this in different ways. And of course, it's right, we're dealing with one or a group of claimants. But in the AIG type of case, you have effectively one fraudulent representation, or series of representations, upon which a large number of investors make exactly the same investment decision. And one can see in that case, insurers, if they find that they've got 100 claims against them, rather than one claim, are going to be greatly prejudiced by, and may need to be protected against it. But here we have a completely different situation, which is we do not have a series of identical investments. We have two transactions which are in their nature inherently different. One is a purchase, the other is a subsequent loan secured on the property, and we have two completely different acts which the judge held are not similar within the test. One is stealing monies which were held on trust for the client for a purpose, and the other is wrongfully applying for a loan on security of a property with the intention of taking those monies for your own purposes. And so we do have a completely different scenario from the AIG scenario, and whether or not this situation comes within the rubric of similar acts or omissions in a series of related matters or transactions is I think we're all agreed, a matter of intense fact-sensitive analysis. And the judge concluded that they weren't similar acts and they weren't a series of related matters. And in a sense, you've helpfully showed us the materials and say, yes, they are.
Indeed.
I just wonder how far we take it.
I've set before the court the material which shows what I say are highly relevant connections and linkages between the two matters. And of course, the court has my point, the obvious point. It's a precondition. It's a gateway point for the consideration of this aggregation provision, that you're dealing with two transactions. If my subclause B point were to prevail, then it would be one matter of transaction, but suppose it doesn't, which it may well not. By definition, you've got two transactions here. Very well. You've got fraud 1 and fraud 2. But you've got in substance, as a matter of economic substance, one victim, you've got one fraudster, and you haven't got Turkish development and Moroccan development, you've got one property.
And what you would say is you've got a fraudster who's got these claimants in his clutches because he's their solicitor, he's been able to arrange it, and he's basically stripping the money out in different ways.
He is.
And he first of all did it by taking the money in escrow or whatever, however it was held, and now he's taking it out by effectively a fictional loan.
He is. Exactly. They are caught in his web. Their interest in both purchasing and developing Claymont Castle, what underlay the acquisition of that property, has caused them to be caught in the web of a thoroughly dishonest solicitor. Of course, the court will have, and anyone ought to have, sympathy with the user of a solicitor who gets caught in a web in that way. It is a disgraceful situation.
But sympathy is in a sense built into the situation, because by definition it's somebody who's been caught by a fraudster.
Indeed.
And the question is, does it come within the terms of the policy or not?
Indeed. Well, it might not be a brazen or a disgraceful fraud of this nature. It might be a relatively innocuous piece of negligence, and we would still there's still room for debate about aggregation, of course.
Yes.
But here it is a disgraceful fraud, and so could be said two frauds, and so one must have, can be said two transactions. Anyone would have sympathy for the defrauded set of claimants. But the words of the aggregation provision say what they say. The Supreme Court has made it clear that one should not add any gloss.
But you can't, because it might be in some situations, it might be in the interest of the claimant to aggregate in order to surmount an excess.
Exactly.
So we got that point.
Exactly. Your Lordship has that point. One comes to it neutrally, and if my submissions are accepted, the court, if they were accepted, the court would end up saying, possibly with reluctance, but that, of course, would not deter the court, would end up saying, well, here we have this provision. There is clearly a relation between what I call phase 1 and phase 2, fraud 1 and fraud 2. Certainly they were different frauds, different transactions, if you like. The court may conclude that, but there was clearly a relation. So the second limb of the provision is satisfied. As to the first limb, I can deal with that, successfully or not, I do not know, but I can deal with that in, I think, a sentence. It's not necessary to show, obviously, that the relevant act or omission was the same in relation to both frauds. It's necessary to show similarity, and it must be a point of substance and not something that is fanciful or very tenuous. That's the effect of what was decided in the first instance in AIG. And the point of substantial similarity is, as my Lord Justice Phillips has just mentioned, is that Mr. Jones was up to the same thing in both cases. He was stealing the money which belonged to the economic unit represented by the three claimants. And for good measure, he was doing so in connection with the castle. But he was stealing that money. It was the same. It was the same type of fraud practiced, perpetrated on the same.
Well, what the judge says, in relation to the surplus funds claim, the act or omission giving rise to the claim was the wrongful release of money from the client account, whereas the Dragonfly loan claim, the act or omission was, 9 months later, the wrongful arrangement of a facility and charge drawn down under the facility and then released from the client account. And he says that the detail there, they are not within the substantial degree of similarity.
He does more. One should, with respect, it seems to me, considering that passage, paragraph 162, tab 7, page 150, core bundle, one should add the word wrongful before the word release in the last line, because clearly the release of money from the client account in relation to the £5 million was as wrongful as the taking of the money from the initial advance made by the claimants. So once one's done that, one sees exactly the same phrase in relation to both phases, or frauds, the wrongful release of money from the client account. Now, my own friend, as I read his skeleton argument, has another form over substance point to make in relation to this. He makes the point that the unauthorised taking out of the loan and the making of the charge, the execution of the charge, was itself wrongful, a breach of duty, etc., which is certainly true. And he makes the point, fairly enough, that breach of duty in itself might have given rise to a liability, because it might have been necessary, would have been necessary to incur perhaps quite modest expenses, sorting things out, rectifying matters, even if the money had stayed where it should have stayed in client account. So my friend says, there we are. We have a very significant difference between the two thefts. Again, I expect to invite the court to place substance over form. The court is considering whether the insurers are entitled to aggregate the two claims that are actually being made in these proceedings. No claim is being made for the very modest costs of sorting out a charge that shouldn't have been granted. The court is considering two claims based upon the theft of client money. That's the reality. And in each instance, right at the centre of what Mr. Jones did wrong, the act or omission generating the liability, was the outrageous theft of a very substantial sum from client account, of client money for his own purposes. And so I respect this, I can undoubtedly demonstrate substantial similarity between the two relevant acts or omissions.
You say in both cases money was wrongfully taken out of the client account. And in a sense, in both cases, the money had wrongfully been procured for the client account because plainly Mr. Jones's intention was fraudulent from the outset.
Looks like it. From what we will see this afternoon when I come to look at some of the condemnation material, that is a fair inference. It was theft. It was theft from its substance, part J. Ladyship's point, but it was theft in substance from one economic, from a set of clients representing one economic unit. And there we are. I can't improve that submission, and I won't repeat it.
Completely irrelevant to these issues, but just out of interest, was this a situation where Mr. Jones was hoping and intending to continually rob Peter to pay Paul? Is that what was going on here?
Well, that is a matter which, about which I cannot assist the court. Yeah. I will be submitting this afternoon that a great deal of thieving and lading or robbing Peter to pay Paul had manifestly been going on. Yeah. And of course, one thing the court will bear in mind when evaluating the condonation issue is the reality of these situations. Where you've got a dishonest solicitor who helps himself to client money, it does tend to, as in the Bishop of Leeds case, as I call it, it does tend to go on for quite a long time because this is one of the key underlying commercial aspects of the situation that the court is considering here. The court is dealing with insurance of solicitors' liability. And insurers have to be very alive to the risks that arise in this field for the simple reason that solicitors have unfettered access to large amounts, sometimes very, very large amounts of client money. That is why there is the architecture of the solicitor's accounts rules, which impose onerous and precisely defined obligations. And that is why, one reason why insurers undoubtedly have to approach this particular section of underwriting with considerable caution, because if you have a bad apple, or worse, a collection of bad apples at the top of the solicitor's firm, then clients are vulnerable, but so are insurers to the sort of fraud that we see in this case.
Can I ask you, you indicated, I think correctly, that this is a question of the judge's evaluation. I don't think it suggested he applied the wrong test.
Can I go to the judgment, my lord, and just make
Yes.
a short submission about this part of the judgment?
Yeah.
It starts at it begins at tab 7 in the core bundle, page 149. I know my lord has it open. It begins at paragraph 154. Paragraph 154 sets out the provision. Paragraphs 156 and 157 can be disregarded because they concern the subclause C point that I'm not pursuing. Paragraph 158 cites AIG in the Supreme Court. And there is a subtle, this might be regarded as nitpicking, but there is a subtle omission in the way in which the judge formulates the test here, What Lord Toulson said in AIG was that it was necessary to consider the question whether the transactions in some way fitted together. Now that's a sort of pedantic textual point that one is discouraged from placing heavy weight on in this court, and I fully understand that. But the correct formulation of the test on the basis of AIG is in some way fitted together. There does not need to be a comprehensive fit, does not need to be a particularly snug fit. It's just necessary for the transactions in some way to fit together. Then the loan judge says that in some cases a purchase transaction and a lending transaction might fit together, but in this case they do not. And at the top of the next page, he observes that the first claim involves the theft of money under a proposed purchase transaction, not depending on a loan, whereas the second claim concerns the theft of monies that had been lent to the client under a secured lending transaction. As to that, I respectfully submit that there, the loan judge is really not doing anything very much more than identifying what is a given, as I said, namely that there were two transactions here, contrary to my subsection B argument, which I'm close to abandoning, but there were two transactions and two frauds here. But that's all.
Well, I don't know. He's making a distinction between the commonplace scenario in which somebody borrows money from an entity in order to finance the purchase of a house, for example. One has to be careful of the word depend for all the reasons that you've come up with, and we know that dependence doesn't have to be shown, but it may well be that somebody could afford to buy the house outright, but they nevertheless decide that they're going to structure it by finance in the normal way. And what the judge is saying here is it's not that sort of situation where somebody has chosen to borrow money in order to finance the purchase of the property where you would have a fit between the two transactions. What you've got is a purchase transaction that's got nothing to do with the finance transaction, and then having purchased the property, there is a subsequent secured lending transaction which facilitates a further theft. So he's not just identifying that there are two different transactions. He's explaining why he doesn't consider that there is a fit.
But yes, I accept that the one feature of this case is that the secured loan that was taken out in January 2019 was not a typical mortgage that was taken out in advance of the purchase and involved raising monies that were used at the point of purchase. If that had been the case, then
that would be open and shut.
Yeah, it'd be open and shut. I doubt we would even the case, this point in the case, would have even come to court. That, of course, is I fully accept, and it's perhaps fair to say that the loan judge is making that point there. But may I just maybe come back to that passage, but just complete my. Very keen to finish this subject before we break. I complete my submission as to this part of the judgment. Paragraph 159 summarises the arguments, some of which will now be very familiar to the court because they do to a large extent reflect some of the arguments I have advanced this morning. Paragraph 160 is the paragraph in the judgment which addresses the related transaction issue, the second stage of the test. And the loan judge says that he accepts that relationship to the property, its purchase and Jirehouse are among the points to be taken in the round, but the points are at a high level of generality. And there is further detail to be considered. In the present case, the detail unravels the relationship of the matters and transactions and the fit of the transactions with each other. I pause there, and I do have to make this submission. With great respect, a reader of this judgment simply cannot tell what the learned judge had in mind when he refers to the detail unravelling the relationship of the matters and transactions. He has accepted, perhaps at a high level, prima facie relationship, prima facie connecting factors, and then he has evaluated the matter on the basis that the detail unravels the relationship of the matters and transactions, but he does not tell, with great respect, the reader what that detail is. What is it about what was and wasn't taking place, what was and was not taking place in late 2018 and early 2019? What precisely is it? Which means that it is proper to conclude that there was no or an insufficient relationship between the transactions. Then he goes on to observe that the opportunities for theft do not answer the question whether the transactions fitted together. Well, they may not answer it, but they don't answer it in the negative. Then in relation to point B, which is the point that I have made, that a loan was contemplated from an earlier stage, mitigates but does not remove the degree of separation between the provision of purchase monies and the later loan. Now, there I do respectfully submit that the loan judge is coming close to committing what I think of as the two-transaction fallacy. Made the submission clearly correct that it's a precondition to this question arising that there have to be two transactions. There, in relation to the important point that a loan was contemplated during the currency of the purchase transaction, the loan judge says that point mitigates the degree of separation. Well, if one analyses that amounts to a finding that that point is, to some extent, a connecting factor, which it obviously is. And then, when the loan judge says that that point does not remove the degree of separation, he's already, by using the term mitigate, accepted that it lessens the degree of separation, and is close, I do respectfully submit, as close to treating the fact of some separation between phase one and fraud one on the one hand, and phase one and fraud two on the other hand, as being determinative. But it can't be determinative because there's got to be some separation for you to have two transactions. I do respectfully submit that one doesn't get very much that assists the respondent from the second last sentence of paragraph 160. And then, as to point E, well, that point is treated as not determinative. That's the point as to the three claimant companies being very closely connected. Now, that, with great respect, that is it so far as the learned judge's evaluative analysis of the second stage of the aggregation issue is concerned. And if one were to suppose, one were to conduct a thought experiment and suppose that the only point in this case had been aggregation, then I do respectfully submit that the court would be a little surprised, might be a little surprised, to find that a 2.75 million issue as to aggregation had been dealt with as shortly as we see here, at paragraphs essentially.
Well, we usually commend concise judgments.
I know.
And it seems to me, at the end of the day, what the judge, I think it's really at the end of 158, what he's saying is, look, there were two transactions here, undoubtedly, at least in some senses. One was the purchase of a property, and the other then was subsequently raising money on that property. And those are not only separate, but they are different, and they don't fit together in the sense that the second you could have had the first and then not had the second, and that it is another further transaction which that doesn't in this context fit together, and that's the judge's assessment. And I think the point I was going to ask you before is, although it's not a discretionary decision, it's not a finding of fact, nevertheless the authorities are clear, are they not, that on a question of evaluation we do have to give a degree of respect to the judge's decision.
Yes.
And particularly a commercial court judge who's heard all the evidence in great detail has reached the conclusion that these two transactions do not fit together. And whilst we do have the material, we plainly have to respect the fact that he has reached that evaluation.
I accept that principle. Of course, I accept that principle is well established by many authorities. However, the weight that this court ought to give to an evaluation of this nature depends on many factors, and if I may, I'll reserve my overall submission as to the weight that this court should attach to the learned judge's evaluations once I've completed my critique of his treatment of condonation.
Thank you.
I'm subject to perhaps one or two tidying up matters which I might even leave alone. That covers the ground on aggregation, I'm glad to say, so I can move to condonation.
Does that mean you've abandoned B? Because if you covered the ground,
May I confirm or deny that at 2 o'clock, my lord?
Well, I hope so, so long as if you deny that. I'm not sure how much longer you're going to spend on B, but there we are.
I'm not going to spend any more time on B. I can confirm that. I can't afford to. I need to get to condonation.
Well, I think that pretty much answers the question, doesn't it? Very well, 2 o'clock.